Welcome back, dear students. Today we will learn the drafting of a criminal complaint under section 138 of Negotiable Instrument Act 1881. And here is the list of books for your reference. You can pick up one or more of these books for learning how to draft a criminal complaint under section 138 of Negotiable Instrument Act. Dear students, you must know the summary of section 138 to 146 of Negotiable Instrument Act before you start actual drafting of this complaint. The rule number 1 of this summary is that check is to be presented in bank within 3 months from the date when check is drawn or within its period of validity. Period of validity of a check is 3 months with effect from 1st April 2012. Before that, it was 6 months. Rule number 2, the payee or dry means in whose favor the check is issued has to make a demand for payment by giving a notice in writing to the drawer of the check within 30 days from the date of receipt of information from the bank regarding return of check as unpaid. So drawer has a period of 30 days. These 30 days are to be counted from the date of information from the bank that check has been dishonored. Then rule number 3 is that drawer of the check, if he fails to make payment of money to the payee or drawee or to the holder in due course of the check within 15 days of the receipt of the said notice, then you get a cause of action for filing a criminal complaint. Rule number 4 is that complaint case in writing is to be filed within 1 month of arising of cause of action in the court of first class magistrate, that is judicial magistrate first class or metropolitan magistrate. Then metropolitan magistrate or judicial magistrate class 1 has the jurisdiction to entertain the complaint under section 138 of Negotiable Instrument Act. Rule number 6 is that it will be a summary trial in view of section 143 of Negotiable Instrument Act, but the procedure of summon trial is to be adopted in view of section 262 clause 1 of CRPC. Rule number 7 of this summary is that punishment up to 1 year and fine not exceeding 5,000 rupees can be imposed if the accused is tried summarily under section 143 of Negotiable Instrument Act, but a punishment up to 2 years or twice the amount of the check or both can be awarded in view of section 262 clause 2 of CRPC and 138 of Negotiable Instrument Act, if tried as trial of summon cases in view of second proviso of section 143. So it is the discretion of the court. If the amount of check is small, accused may be tried summarily. But if the amount of the check is very high, then accused may be tried as summons trial. And in summons trial, the punishment up to 2 years or twice the amount of the check or both can be imposed by the court. Dear students, you know that the maximum power of a judicial magistrate class 1 is 3 years imprisonment and 10,000 rupees fine. I'll write down here judicial magistrate. Judicial magistrate class 1. So these are the powers of judicial magistrate class 1, that he can impose maximum imprisonment up to 3 years and maximum fine up to 10,000 rupees. And if fine more than 10,000 is to be imposed, because you are imposing fine double the amount of the check, Then case should be sent to the Chief Judicial Magistrate under section 325 of CRPC, because there is no fine limit which a CJM can impose on an accused. Then rule number 10, dear students, is that this dishonor of check under section 138 Negotiable Instrument Act is a no FIR case. I will highlight it. It is a no FIR case. Only complaint case can be filed in the court concerned, and police has no power to register FIR in such cases. And rule number 11 of this summary is that presumption of dishonor of check on the basis of memo of dishonor issued by the bank is there under section 146 of Negotiable Instrument Act. Once the bank has issued a memo of dishonor, there is a legal presumption that check has been dishonored. And last 12th rule is the conclusion that the cases of dishonor of check shall be tried summarily, but they may be tried as summons trial if the court thinks fit in cases where the amount of check is very high. And if court opts to try the case summarily, it has to adopt procedure of summary trial. But if the court is not bound by the limit of imprisonment of 3 months in a summary trial, only procedure of summary trial is to be adopted. This is very important point, that if court opts to try the case summarily, it has to adopt the procedure of summary trial, because it is written in section 262 of CRPC. But the court is not bound by the limit of imprisonment of 3 months in a summary trial. What is to be adopted is only procedure of summary trial. But the maximum limit of punishment in summary trial is 3 months. That is not to be followed. All right. So dear students, now we have a complete summary of section 138 to 146 of Negotiable Instrument Act. And keeping in mind all these provisions, we have to draft a criminal complaint in the Court of Judicial Magistrate Class 1 under section 138. So as usual, my dear students, you will have to choose the name of the court first of all. So in this illustration, the name of the court which I have chosen is in the Court of Chief Judicial Magistrate, Noida, District Gautam Buddha Nagar, UP. The advantage of this court is that there is no fine limit which can be imposed by the Chief Judicial Magistrate. So when you impose a fine rating it double the amount of the check, then there is no problem with CJM. But for Judicial Magistrate Class 1, since his powers are limited to a fine to the extent of 10,000 rupees only, there the problem may come. If the amount of the check say was 40,000 rupees, and fine is to be imposed, say double of it, 80,000 rupees. So Judicial Magistrate Class 1 will have no jurisdiction to pass such a sentence. But Chief Judicial Magistrate, since he has no limit of imposing the fine, that's why I have chosen the name of the court as Chief Judicial Magistrate, which is of course a Class 1 magistrate posted in Noida, District Gautam Buddha Nagar. Then criminal case number 138 of 2020. 138 I have highlighted just to remind you that you are resorting to the provisions of section 138 of Negotiable Instrument Act. As usual, the name of the complainant will come first. Mr. X, son of Y, is our complainant with his complete address, versus this case is filed against A, son of B, who is also resident of District Gautam Buddha Nagar. He is accused. And the police station under whose jurisdiction this offense of dishonor of check was committed is Sector 50 Noida in District Gautam Buddha Nagar. The center heading will be complaint under section 138 of Negotiable Instrument Act 1881 as amended up to date for the sum of rupees 10 lakh only. Dear students, you remember that we had originally adopted an illustration of sale of a flat by builder in favor of purchaser in 1 crore rupees, and 10 lakh rupees were given in advance by the purchaser. Now it is the same check, 10 lakh rupees, which is dishonored now, and the builder is now the complainant, saying that the purchaser has given me a check of 10 lakh rupees, which has been dishonored by the bank. Opening salutation sentence will be, the complainant most respectfully sheweth as under. Now you will write down the facts in small paragraphs to be numbered consecutively one by one. Para 1. Para 1. The complainant is working as a builder in Noida and is residing at 910 Designers Park, Sector 62, Noida, District Gautam Buddha Nagar. Fine, this is the address of the complainant. Para 2. That the present complaint is being filed Para 2, that the present complaint is being filed by the complainant, Mr. X, son of Y, to cause appearance in this honorable court and to depose and conduct the proceedings. Para 3, that on 1/1/2017, accused A agreed with complainant X to purchase a flat for the sum of rupees 1 crore, wide agreement dated 1/1/2017, and a sum of rupees 10 lakh were paid by A, son of B, by check number 234876, dated 1/1/2017, drawn on Sector 82, branch of SBI, Noida, District Gautam Buddha Nagar. Yes, it is the same story. Para 4, that towards payment of honest money, the accused issued check number so and so, dated 1st January 2017, for 10 lakh rupees only to the complainant, and in order to discharge his above said liability, and in accordance with the agreed terms and conditions, the said check was issued from saving bank account of the accused, which is held in the name of accused A. That the present complaint is based on the dishonor of the above said check, which was issued in discharge of part payment for the purchase of the flat. Para 5. That at the time of handing over of the above said check, the accused has assured the complainant that the said check will be honored on presentation. Taking the above assurance or representation as true, the complainant had accepted the above said check. Para 6. That on the basis of assurances given by the accused, the complainant presented the above said check with its bankers, namely SBI Sector 62 branch, Noida, on 10th January 2017. But the check was dishonored by check return advice dated 17th January 2017, issued by the complainant's bank. Therefore, such check was returned unpaid, while returning memo dated 17th January 2017 with the remarks, funds insufficient. This remarks means that the accused was short of funds. He had no credit to the tune of 10 lakh rupees in his saving bank account when the check was presented for its clearance. Then para 7, that the dishonor of the check clearly shows and establishes that the accused did not intend to honor the amount under the said check. Para 8, that on account of the dishonor of the said check, the complainant had served a legal notice dated 1st Feb 2017 upon the accused by means of registered post by receipt number speed post number 123456, dated 1st Feb 2017. However, despite service of notice on 4th Feb 2017, the accused has not taken any steps to liquidate his liability and has failed to make the payment to the complainant towards the amount covered under the said check within the statutory period of 15 days, that is up to 19th Feb 2017 or even thereafter. Para 9. Thus, the accused has therefore committed an offence within the meaning of Section 138 of Negotiable Instrument Act and other sections of amended provisions of Negotiable Instrument Act 1881, for which he is liable to be prosecuted and punished. Then para 10, that the accused has failed to make payment against the said check which was issued by him intentionally, deliberately, and knowingly that he had no or little funds in his account. Then para 11, that at the time of issuing the said check, the accused was fully aware that the said check will not be honored on presentation. Therefore, the accused has dishonestly induced the complainant to purchase the flat and issued a check of rupees 10 lakh, fully knowing that he cannot pay the said amount to the complainant. Para 12, that the accused is guilty of offense under Section 138 of Negotiable Instrument Act and is also liable to be prosecuted under Section 420 of Indian Penal Code. Para 13, that in view of facts and circumstances narrated above, the complainant has a cause of action and right to file the present complaint. The cause of action has arisen in favor of the complainant when, on the expiry of the notice period, the accused has not come forward to pay the amount related to the dishonored check. The cause of action is still subsisting and is continuing in nature. Para 14, that the cause of action has arisen at Noida as a check was issued at Noida, District Gautam Buddha Nagar, and the same was payable at Noida and was also dishonored at Noida. Therefore, this Honorable Court has jurisdiction to try and adjudicate upon the present complaint. Para 15 gives the summary of entire complaint, that the complaint is well within limitation period prescribed under Negotiable Instrument Act. The relevant dates and sequence of events are as under: A. Date of check was 1st January 2017. Date of presentation of the check in bank was 10th January. Yes, it can be presented within 3 months. Then dishonor of the check was on 17th January 2017. Then date of notice of demand of rupees 10 lakh is 1st Feb because the notice was given on 1st Feb 2017. And date of receipt of demand notice was after say 3 days. On 4th Feb, the notice was received by the accused. And accused has 15 days time from 4th Feb, that is up to 19th Feb he could have made the payment of 10 lakh rupees, but he has not done so. And from this date, within 1 month, the complaint is to be filed before the court. So date of filing of the complaint is 1st March 2017. So that is well within period of limitation as prescribed in the Act itself. Para 16, that a list of documents and list of witnesses are annexed with this complaint. This is compulsory requirement of CRBC that no summons shall be issued against the accused person unless a list of witnesses and list of documents is annexed along with the complaint. Now finally, you are to draft the prayer clause also. Center heading prayer. It is therefore most respectfully prayed that this honorable court may be pleased to. Now you have prayer number 1A. Your prayer is that honorable court may be pleased to summon, prosecute, and punish the accused, and also direct the accused to pay double the amount of the check, that is 20 lakh rupees, covered under the said dishonored check under provisions of Section 138, read with 142 of Negotiable Instrument Act 1881, as amended by Negotiable Instrument Laws Amendment and Miscellaneous Provisions Act 2002. So you are demanding that accused should be summoned, prosecuted and punished, and he should be directed to pay double the amount of the check, that is 20 lakh rupees, to the complainant. The relief is that in accordance with section 357 of CRPC, out of penalty imposed, the accused be ordered to compensate the complainant to the extent of 20 lakh rupees. You see, whenever a fine is imposed upon the accused, fine is deposited in the government account. But section 357 of CRPC authorizes the magistrate that out of the penalty imposed, out of the fine imposed, accused may be ordered to compensate the complainant. So here the prayer of the complainant is that a fine of 20 lakh rupees should be imposed on accused, and out of that fine, the sum of rupees 20 lakh rupees may be ordered to be paid to the complainant as compensation. And third relief is usual to write down such other and further order or orders as may be passed, as may be deemed fit and proper by this honorable court, may kindly be passed. After the framing of relief, you will write down place where this complaint was drafted. Place is Noida, district Gautam Buddha Nagar, UP. Date of filing the complaint is 1st March 2017. Then you will have to obtain the signature of the complainant on this complaint. And since this complaint has been drafted through some advocate, that is XYZ advocate, you will mention this spectrum also. And then signatures of XYZ advocate are also required to be appended on this complaint. So dear students, this is how we have learned the drafting of a complaint, drafting of a criminal complaint for dishonor of a check under section 138 of Negotiable Instrument Act. So thank you very much, dear students. God bless you.